The honourable member for Edmonton St. Albert.
Thank you very much, Mr. Speaker. It is really a pleasure for me to speak to these amendments that you have just deemed to be admissible with respect to report stage with respect to 461 dealing with public sector transparency. Mr. Speaker, this bill in its original form intended to do two fairly modest things. It attempted to remedy a well-documented and often litigated flaw in the Access to Information Act regarding the public broadcaster. Section 68.1 has been the matter of no less than 14 separate pieces of litigation between the Information Officer and the Canadian Broadcasting Corporation. Both the Federal Court and the Federal Court of Appeal held 68.1 of the Access Act, brought in 2006 by this government, to be flawed in its drafting because it created an exclusion subject to an exception. 68.1, and I'm paraphrasing, says that the Act does not apply, that is, the Freedom of Information Act does not apply, to the Canadian Broadcasting Corporation, to documents and its information that relate to its journalistic, creative, or programming activities, other than that information that relates to its general administration. So you can see the problem. It creates an exclusion. This Act does not apply, except under certain circumstances, i.e. matters regarding to general administration. So in my view, and I think in fairly well-documented examples, the Canadian Broadcasting Corporation was able to use 68.1 to deny disclosure of documents that were under access request. And the fact that the Act did not apply indicated that there was no power of review from the Information Commissioner. The Information Commissioner gets her powers of review from the Act. So if the Act does not apply, there's no power of review. So this bill, in its original form, attempted to remedy this. It attempted to remedy what two federal courts indicated was not a model of clarity and that it was very awkward in the drafting. And in fact, the Standing Committee on Access to Information, Privacy and Ethics did a complete study on 68.1 because there was so much controversy and so much misunderstanding, and of course 14 pieces of litigation between the Information Commission and the CBC. And they heard testimony, and the Information Commissioner, Ms. Legault, testified in front of the Standing Committee on Access, and she recommended that 68.1 be repealed and that it be replaced with an injury-based exemption, not an exclusion, but an injury-based exemption, and it would be discretionary, so that if the test was made out that the CBC would somehow be injured in terms of its independence, then she would recommend against disclosure, but if there was no prejudice or no injury, then she would recommend that the documents be disclosed. It all seemed perfectly reasonable at the time. So that recommendation was incorporated in the original C-461. But we heard evidence at the committee, and we had a number of hearings. I'm not a member of the committee, but I sat through them as an interested member and the sponsor of the bill, and we heard cogent evidence that the independence test was too narrow, and it created a level of discomfort both within the broadcast industry and certainly within the public broadcaster, that the independence test was too narrow, and that test might be expanded or expanded to include something similar to protect not only the independence but also the freedom of expression of the corporation. I conceded at my last of my third witness appearances before that committee that would be helpful, that type of wording to protect not only the independence of the corporation, but also its freedom of expression would be helpful, and it would give a greater level of comfort both to the industry and certainly to the Canadian Broadcasting Corporation. But the committee, or at least the majority of the committee, was disinclined to accept that type of a recommendation, so it was not passed. But the committee did pass a most unhelpful amendment regarding journalistic source protection. Now, you recall, Mr. Speaker, that the problem with 68.1, as it still is in the Act, it's still the law today, is the exclusion at the beginning. The words, "This Act does not apply." So what does the government do in its amendment at committee? They grant another exclusion. They provide an absolute exclusion for journalistic source privilege. This Act does not apply, which means the Information Commissioner has no powers of review. Therefore, decisions of the Canadian Broadcasting Corporation with respect to journalistic source privilege are absolute and not subject to review by the Information Commissioner. And the inevitable result of that untenable situation is litigation, and the Information Commissioner has said so as much when she appeared before committee, that if her powers of review are compromised, she's going to have to go to court to get clarification of those powers, because Section 36 of the Act gives her unfettered power to review documents under the control of government institutions. So the government, in its so-called wisdom, proposed the exact same problem that we just set out to remedy, and that is we were replacing the exclusion in 68.1 with a discretionary exemption, and then they go ahead in their amendments at committee and provide an exclusion with respect to journalistic source privilege. So I believe, and I say this with some regret, but I believe that the amended bill, as amended by the Access Committee, is actually worse than the status quo, that is, the existing provisions regarding the Access to Information Act. My intent was to provide clarity and certainty and to have less litigation rather than more litigation. And the one thing that the government refused to do, and that was to entertain amendments regarding extending the discretionary exemption to include freedom of expression, in addition to its insistence that an absolute exclusion be given with respect to journalistic source privilege, I think makes this a bad piece of legislation with respect to the CBC access. So I am proposing in the motions that have been tabled the deletion of any reference to access to information regarding the Canadian Broadcasting Corporation, including the name of the bill. So the motions 1, 2, 3, 4, 6, 7, and 8 deal with the deletion of sections regarding the Canadian Broadcasting Corporation's obligations under the Access to Information Act. I still believe that 68.1 needs to be fixed because it's awkwardly drafted. The courts have called it not a model of clarity. When you have an exclusion and then you limit the exclusion with an exception, you have nothing but misunderstanding and litigation. It has to be fixed, but this bill in its current form does not fix it. In fact, in my view, it makes it worse. Now, with respect to journalistic source privilege, I absolutely understand the importance of allowing journalists to protect their confidential sources. I'm sorry, Mr. Speaker, how many fingers are you holding up? Thank you. What did you say, Chair? 2. With respect, the Information Commissioner has had 1,200 cases before her. Not one has ever dealt with single source or with journalistic source privilege. And besides, the name of an informant is confidential information under the Privacy Act and could not be disclosed. So the CBC amendments at committee were most unhelpful. So with my remaining time, I want to deal with what I think is the most contentious issue, and that's with respect to salary disclosure. Now, this bill attempts to allow an amendment to the Privacy Act to allow specific salary and specific job description disclosure for a civil servant over an appropriate range. The initial range in the unamended Act was the lowest level of DM1, or $188,000. But the committee, in its wisdom, and I say that with more sarcasm than I've ever used before in my life, decided to raise the disclosure bar to $444,000, which is to absolutely ensure that it could not apply to any DM, including a DM4, or anybody below her, or below him or her. Now, I'm not sure how the government reconciles that with Treasury Board proactive disclosure. If you, Mr. Speaker, if you have a contract with the Government of Canada for as little as $10,000, your name and your contract and the value of your contract is on a Treasury Board website. But if you're a Deputy Minister making $444,000, apparently the privacy laws of Canada were made to protect you. Now, the nub of this issue, in my view, is the performance bonus. The Parliamentary Secretary to the Minister of Justice will get up and he'll talk about ranges that we already disclose ranges of salary. And that is true. But at DM4, that's the highest level. The range is $272,000 to $319,000. That's a pretty big range. That's almost $50,000. But that doesn't end it, Mr. Speaker. A Deputy Minister at that level is entitled to up to a 39% discretionary performance bonus, or $123,000. Nothing in our current privacy provisions or in our access to information allows any interested Canadian to find out anything about a performance bonus. And that, to me, is deficient. So this bill attempts to undo the damage that was done by the Access Committee on June 5th of this year, incidentally the same day that I left the Conservative caucus, and promote transparency and disclosure, not opaqueness and secrecy. And given all of the allegations of secrecy and opaqueness that are in this town, I would think that the government would grab my amendments and support transparency and salvage their reputation.
The